we all think we know Bud. But let me just tell you, I'm here to set the record actually straight. Bud was raised on a farm in rural South Dakota. He graduated from the University of South Dakota in 1965 with a BSBA and a major in accounting. He joined the Denver office of Arthur Anderson 2 weeks later. Bud served in the U.S. Army Finance Corps from April 1966 to June 1968, finishing as a captain. He went back to Denver and Arthur Anderson after that and worked in the audit practice for a total of 33 years, retiring as a partner in 2000. Bud is a man, a lifelong servant. Bud has served on the board of directors and as the chair of the audit committee of several public corporations. For 5 years, Bud was the president of the Catholic Foundation of Denver. Bud has also served on the board of the Regis Jesuit High School, and Bud has served on the board of the University of South Dakota Foundation. Bud has been a member of this club and of other similar service-oriented clubs. One of the things we know about Bud is that he's been married to his high school sweetheart, Alice, for almost 59 years. He has 5 children and 10 grandchildren, and if my supposition is correct, and I'm no good at math, but my guess is that latter number will only grow. I personally have had the chance to talk to Bud about his journey as a father and a grandfather, and our paths have crossed in some unusual ways. So to say that Bud has had spare time or any spare room in his heart would probably be a misnomer, because I think every square inch of Bud's life and his heart have been devoted to this vast number of organizations and, closer to home, to literally every person in his family. So it is extraordinary for us to have the opportunity to hear somebody who has a broad perspective as a true community servant and as an unbelievable husband, father, and grandfather, to tell us all about what happened to Enron.
Is it okay if we just stop there?
What if we say yes?
Well, thank you for that wonderful, in some respects, overstated introduction. Appreciate that. My topic is to talk about the Enron Arthur Anderson situation. This happened a long time ago, 2000, 2001, 2002. I can't really talk about Enron and Anderson unless I first tell you a little bit about my history with Anderson. How did I come to work for Anderson, and what did it mean to me to work for that accounting firm? And then we'll talk about Enron, a little history on Enron, and then we'll get to the climax, so to speak, where we talk about the events that led up to Enron's demise and Arthur Anderson's demise, and then what happened after that from a regulatory standpoint. As you heard, I joined Anderson out of college. In those days, you graduated, and then a couple weeks later you went to work. Now you graduate and you go to work in the fall, take the summer off. I was so poor, I couldn't afford to take the summer off. I had to get right back to work. I was very proud of my service with Anderson. I thought it was the best accounting firm in the world, and there's some evidence to indicate that that might have been the case, at least for a period of time. When I graduated, I decided there was only one firm I wanted to work for, and that was Anderson. I had met some people that were partners in the firm. I was very impressed with them. I liked some of the things I read about the firm. And so when I did my interviewing on campus at the University of South Dakota, all the big firms came to South Dakota to interview, but they came from offices like Chicago and Minneapolis. Nobody came from the Denver office. So I interviewed somebody from with someone from the Minneapolis office, and he said, well, if you want to work in Denver, we'll fly you out there and you can talk to the people out there. It's the only firm that offered to do that. So and they put me up in the Brown Palace Hotel when I was in Denver. Wow, this is the one I want for sure. I thought it was the best firm, and I suppose people that worked for other firms thought their firm was the best, so that's the way it should be. The firm Arthur Andersen was founded in 1913 by a man named Arthur Andersen. He was in Chicago. He was had very high integrity, very strong discipline. I'll give you a couple of examples. He passed the CPA exam in Chicago, and he was the youngest person at that time to ever pass the exam in Illinois. I'll give you a couple of examples of how he practiced in the public accounting field. He had a client, a Chicago company. That company wanted to keep certain costs on the balance sheet which should have been written off. And he said, no, you gotta write those costs off. And the company said, no, we don't wanna write them off, we wanna leave them on the balance sheet. It'll make our financials look a lot better. So he fired that client, or they fired him, because he wouldn't change. Then another company came along, a steamship company, and the steamship company was going to issue bonds using the December 31st financial statements of that particular year as an example of how stable that company was. Between December 31st and the time that the audit report was issued, a freighter owned by that steamship company sank. And so Andersen said, well, that's a pretty significant subsequent event. You gotta disclose that. Because if you just look at the financials as of December 31st, it's kind of misleading not to know that one of your freighters sank. That's a big loss. It's gonna cast a little bit of a pall over you, and and the people that buy your bonds need to know that. And the steamship company said, no, we're not gonna do that. So he lost that client too. So the point is, he had integrity, he knew what the right answer was, and he was willing to sacrifice a client to get to that right answer and to preserve that right answer. A little bit about, the other thing I wanted to mention is that during my career with Andersen, there was an annual survey of all of the U.S. accounting professors in the country, and they rated Andersen as the #1 firm among the largest accounting firms in service to clients, technical reputation, staff training, and career opportunities. That happened for 16 consecutive years through 1998. So when I think I was with the best, that's one indication that perhaps I thought I was. Enron. Enron was a result of a merger between two companies, Houston Natural Gas and InterNorth, which was an Omaha company, more state conservative company. That happened in the 1980s, and Ken Lay became the CEO of the combined company. And of course, Enron, that all happened in the Houston office of Arthur Andersen. So I was in Denver my whole career. I didn't really know anything about Enron. I read about it just like you all probably did. Of course, there were rumors that went around the firm when that all happened, but I really didn't know any of the facts or any of the details. So to prepare for these speeches, I did a lot of research. There have been probably 15 or 20 books written about the Enron situation. One of the books is entitled Smartest Guys in the Room. The management and leadership of Enron truly believed they were the smartest guys in the room. A little arrogance there maybe, no? There were several articles written by university professors and others, and in preparing for my talk, I read a lot of that stuff. I read excerpts from the smartest guys in the room. I talked to a friend of mine who is in the natural gas business. And back in the day, he was with a company that did business with Enron. And he said, there's no question, when we met with Enron to talk about a deal or a transaction, the meeting always started with, we are Enron. We are smarter than you are. You're not Enron, so you're not that smart. I said, I can't believe that they actually said that. And he said, yeah, that's how the meeting started. So that kind of sets the agenda for what things were like. They had a process of employee evaluation at Enron, where each employee, when they were evaluated, was given a 1, 2, 3, or 4, or 5. If you were a 1 or a 2, you were a star. But if you were a 5, you might as well put your resume together and start looking around, because chances are they were going to figure out some way to let you go. So that was kind of the attitude. The other thing that I should mention is that their business was natural gas contracting. They would sell contracts with users, and the accounting method they used was mark-to-market accounting. So I don't want to make accountants out of you. We have one accountant in the room who probably understands this, but I don't want to make accountants out of you. But visualize, they sold a contract to deliver gas to a company for 15 years. They would take that contract and they would estimate what the revenue would be from that contract over that 15-year period, present value it back to today, and record that as revenue. They would put the asset on their balance sheet and set up revenue. Now you're shaking your head saying, well, how could that be? It was an acceptable method of accounting, believe it or not. The SEC has reviewed that and approved it as a method of accounting. So the problem with it, as you can probably guess, is how do you estimate what the revenue stream is going to be? What sort of assumptions do you use? Well, the assumptions are limited only by your imagination to some extent. Well, the guy that was the CEO of Enron to start with was Ken Lay. And then he hired a brilliant young man out of an MBA program. His name was Jeff Skilling. And Jeff Skilling looked at this method of accounting and thought, well, okay, there's a little leeway here. We can probably do some things with this. So a lot of judgment went into that, and it was subject to manipulation. Not that they manipulated things, but there's a wide range of what you might consider acceptable. So they were able to use that to their advantage. It would be like Bayard Industries, when they sign a contract to do recycling services for a company for a year or 2 or 3, be like them sitting down and estimating what they're going to charge that company over the 3-year period, present value it back, and book that as revenue today. Well, that's what they did. That was their business model, and they did that for natural gas contracts. They did it for energy, for electric energy. They did it for the broadband business, for transportation. They were very creative. And again, this was accepted practice. The SEC bought this method of accounting. The key, of course, is that you had to disclose in your financial statements what you were doing, what they did, what were the assumptions that you built in to this revenue model. And so they did that. However, the financials, have you ever looked at the financial statements of a public company today, by the way? When you invest in a stock, do you read the financial statements of that company before you invest? No, you don't do that. I don't do that. You look at what the analysts have to say. If you looked at the financial statements, you'd never be able to understand what they're saying. Well, maybe an accounting major would, but the average person wouldn't be able to understand that. So back in that day, the same was true. Those financial statements, one of my partners who was an expert, really strong mentally, intelligence, he had read those. He went through the Enron financial statements, after all this went aside, and he said, everything they were doing was in there. It was all there. If you read the financial statements, you could see what they were doing and what their accounting method provided. If you understood it, but you could, it was there. But people don't do that today. when you invest in a stock, you're basing it on, some people may be based on a hot tip. Other cases, it might be based on what the analysts have to say, or what you hear about on CNBC, places like that. So back in those days, not just back in those days, but at that time, Enron was a high flyer. And if you've seen the movie, The Wolf of Wall Street, I've never watched the whole movie because some of it's kind of R-rated, but if you look at certain portions of it, watch certain portions of it, you know, they get all excited about, come on, go out there and sell this stock, it's a winner, it's gonna go, go, go. Well, a lot of that happened during that period of time, and Enron was one of those hot stocks. Its market, the stock price was as high as $90 a share. And when guys in the company got these contracts signed up that they booked on a mark-to-market basis, their commission was rewarded to them in the form of stock of the company. So these guys made really good money. It would be, you know, a little bit like if you're a real estate broker or a real estate salesman, it'd be like getting a commission when you sign the listing contract. Not when you actually deliver the sale of the house, but when you sign the listing contract. And again, since the revenue recognition was possible and they wanted to encourage their salesmen to do this, they had a pretty hefty commission system set up, and people got stock for their hard work. So that just kind of put more fuel to the fire, so to speak, and they continued on. Well, just like most other high flyers, you get to a point where it's really hard to continue to do it, because you make your quarterly numbers, that's great, stock price goes up, then comes another quarter, you gotta make those numbers too. You keep on going like that, and it worked. I mean, Enron started in like 1985, and you know, they were strong through the 1990s, but towards the end of the 90s, 1998, 99, 2000, 2001, they sort of ran out of the ability to do these kind of deals. So they would come up with other ways. Again, all permissible. But if you read the financial statements, you would see that, you know, this isn't the kind of recurring. They could build a power plant and estimate the revenue that that power plant would generate, and they could put that on their balance sheet and reflect the difference between the cost of the power plant and that value in their income statement. And again, that all had to be disclosed, but you wonder, it's sort of like that real estate guy using that example. He signed the contract, he got the contract for the listing signed, he hadn't done anything yet, but he got a commission for it. Well, so he just goes out and signs more and more contracts, right? He's going to get, the reason I use that as an analogy is that one of the issues with Enron was that their compensation program rewarded the wrong thing. It didn't incentivize the right thing, which, in my opinion, would, by the way, some of what I'll tell you today is factual and some of what is my opinion. So I'll try to say, in my opinion, when it's appropriate. But in my opinion, it's more appropriate to receive your compensation when you actually get the deal done. And it's just like these gas contracts, instead of recognizing the revenue up front based on mark-to-market accounting, it makes more sense, in my opinion, to recognize that revenue over the life of the contract as it is realized and as it is received. The other thing about this, if you recognize revenue on a contract over its life, you know what comes with that? Cash. You get cash. If you recognize the value of that contract up front based on all kinds of estimates, there's no cash yet. So one of the points that people made who looked at their financial statements was, yeah, they had a lot of revenue and they had assets on the balance sheet, but where was the cash? How much cash were they collecting? Well, that was coming in over a period of time, so that was much slower, and there was kind of a dichotomy between the revenue recognition and the cash. And so this went on for quite a while. As I said, the CEO was Ken Lay. He hired this hotshot MBA, and he guy really was smart, no question about it, named Jeff Skillings. Then they had a CFO named Andrew Fastow. The other thing that Enron was able to do, again, in accordance with the rules, they had these off-balance sheet entities called special purpose vehicles. You could put these you could put liabilities in these special purpose vehicles and not reflect that on your financial statements. Again, you raise your eyebrow, that, oh, it was appropriate. There are rules that allowed them to do that if you met certain criteria. So they were very careful in structuring their transactions to meet that criteria. Now, there was one situation where, and of course these financial arrangements also involved dealing with investment banking firms. There was one situation where a deal was set up and there was a verbal side agreement with an investment banking firm. I don't remember which one it was. But the verbal side agreement, had the auditors known about that, would have avoided the treatment of that transaction. But because it was verbal and it was kept from everybody, you know, I scratch your back, you scratch mine. We don't tell anybody about this deal. We'll do more deals. It'll be great. Do this a little favor for me. That's what happened. At least one transaction. Were there others? I don't know. But factually, there was at least one. The other thing that went on is that with these special purpose entities that were not on the balance sheet, off balance sheet financing, you've probably heard the term off balance sheet financing. That happens, and they meet certain criteria. That's possible. It would be sort of like giving your kids credit cards and charging all the stuff you need on your kid's credit card, but then when you went to the bank to get a loan, you didn't report your kid's liability on those credit cards. You just show them your liabilities. Not a good analogy perhaps, but that you kind of get the idea of what was going on. And by the way, this mark-to-market accounting, it wasn't unique to Enron. There were several other energy companies that were doing the same thing, using the same method of accounting. But
did anybody ever lose money on one of those mark-to-market accounting schemes?
well, I mean, the contracts were real, and they worked. And we agreed to provide gas for 15 years, and they provided gas for 15 years. So there wasn't any money loss per se, but it was a way to kind of manipulate. Just visualize this: you reevaluated the value of those mark-to-market contracts at least once a year when you did your financial statements. And sometimes you could do it on a quarterly basis. So visualize, Enron's on this treadmill of reporting quarterly earnings and having to, this quarter has to be better than last quarter, so on and so forth. So, okay, we need a little more revenue this quarter. Take another look at some of those contracts and see if those assumptions are still valid. In my opinion, that was something that they could do. I'm not sure they did that, but it was certainly possible using that method of accounting. So this went on, yeah.
Well, I'm struggling here to establish whether the accounting system ever established any ethical code of conduct regarding their behavior.
Well, a lot of things happened after 2001, 2002.
There wasn't no code of ethics at that time.
Well, each company had a code of ethics. Enron had a code of ethics. But who was enforcing that code of ethics? Then the SEC and the regulatory agencies got involved after everything went asunder. Sarbanes-Oxley was instituted, was legislated. It created all kinds of requirements. You know, when a public company up to that time filed their financial statements with the SEC, oftentimes if there were problems with the financial statements and the shareholders sued, they'd get the CEO on the stand and he'd say, well, I didn't prepare the financial statements, I'm not in charge of accounting, you know, I've got a CFO, they're in charge of that stuff, not me, I'm not the one. Well, after Sarbanes-Oxley, they required the CEO and the CFO to sign a statement that goes with the annual financial statements where they certify that they are responsible for what's in the financial statements. And I don't know that the CEOs have done any, in all cases, did a lot more due diligence after that as a result of that. But that was something we could bring up at times when I was an auditor. I could say, look, these are your financial statements. You're taking responsibility for these things. If you don't want to make this adjustment, you know, that's on you. It's not just on the financial people. So that had some weight. Things were going along. Enron, as I said, was a hot stock, $90 a share. When things began to fall apart in December of 2001, stock price was 26 cents a share. Now, the other thing I should mention is that there was a period of time in October of 2001, Enron announced its first quarterly loss ever, $618 million. They had a profit in the first quarter of $536 million. Then 2 quarters later, they lost $618. So things were beginning to unravel. But during that time, they decided to change administrators for their 401k plan. So all the employees who had 401k plans, which were loaded with Enron stock, couldn't trade for about a 30-day period, because when you change administrators, you get locked out of the market. And of course, the Enron people said, well, we told the employees, we gave them 30 days notice that we were going to do that. But of course, you take the a guy who's working on the line for an electric power company in Oregon, who, because he believed in Ken Lay, put all of his 401k money into the company stock. I mean, he's not sophisticated, he doesn't know. So he's got money in the 401k plan loaded with Enron stock. First mistake, of course, you need diversification, but we've all probably committed that sin, you might say. And they did that then too. Those 401k plans for those employees were loaded with Enron stock. So when the value went down, it really affected them. I had a sister-in-law who worked in Brookings, South Dakota. She worked for a power company that was acquired by Enron. She had Enron stock. And when it went down, she said, "You work for Anderson? You're the auditors for Enron? That all went worthless. Where were you? What was going on?" It wasn't me, it was Houston office, not me. And that's true. Let's see. There have been, like I said, 15 or 20 books written, so I had to kind of boil things down a little bit to get to what was appropriate here. Okay, so when things came tumbling down, Anderson, with a little help from the SEC, decided that financial statements for several years, going back to 1997 for Enron, had to be restated. When that happened, the SEC really got their attention big time, and they decided to investigate. They investigated, then the Justice Department got involved. And typically, when there was an accounting failure or financial statement failure for a public company, if the shareholders would always sue the auditors, because that was the so-called deep pocket. Sometimes they would sue the investment bankers, but the auditors always got sued, whether it was justified or not. And typically, they would go through a period of time of, you know, depositions and discovery and all that sort of thing. And then eventually it'd get to a point where the defendant would work out a settlement. So the firm, Anderson's case, and all the other accounting firms, they'd go through this, and they paid big chunks of dough out of their D&O coverage to make the lawsuit go away, and then most of the time it was without admitting any guilt. So that's what I think most of us figured was going to happen to the firm, that we would, you know, end up paying a large settlement and move on, change our ways and move on. Well, that happens except when the Justice Department is involved. The Justice Department was not buying that. So they did their investigation, and by the way, when things began to unravel, the audit partner in charge of the engagement in Houston started shredding documents. Now, on the surface, that makes you wonder, right? Why are you shredding documents? Well, we're just trying to clean up the files, clean up the office, get rid of some junk. And a lot of it, and that was true for a lot of it. When I heard that they were shredding documents, I said, well, that smocks of guilt. But as it turned out, most of what they were shredding was stuff that didn't have any real relevance, but it didn't look good. Didn't look good at all. So the Justice Department begins their investigation, and at that time, when they were shredding the documents, we did have a document destruction policy or retention policy. And one of our internal legal counsel from Chicago wrote a memo describing what the document retention policy is. And the memo was sent out to the Houston people, and when it was sent out, the lawyer, our internal lawyer, who had been with the firm for about a year, very inexperienced, said, don't put my name on that memo. I don't want my name on that memo. So they took her name off the memo. They didn't change the memo stayed the same. And how many of you in your business have written memos that you later went back and edited or changed or did something different to it? Well, in this case, the Justice Department really glommed onto the fact that she took her name off that memo, and they call that obstruction of justice. So Arthur Andersen was indicted for obstruction of justice. The whole firm, not the Houston office, not the people that were involved, but the whole firm. 80,000 employees were affected by this, partners and employees. So, long story short, the attorney from the Justice Department that made that decision was Michael Chertoff. He later became the Secretary of Homeland Security. One of his first projects with Homeland Security was dealing with the aftermath or problem with Katrina. I'm sure there were a few, and he got a lot of criticism for the way he handled that. I'm sure there were a lot of Andersen people around the country thinking, what's fair is fair. But anyway, he and the Andersen people sat around the table negotiating one weekend about what the Justice Department was going to do, what they were going to require Andersen to do. And Andersen had decided that they decided to fire David Duncan, who was the partner on the engagement. They replaced all of the management of the Houston office and put several other partners on extended leave, which means that extension is going to go on into infinity. So they got rid of what they thought were the bad players. But Michael Chertoff on a Sunday night said, I'm going to sleep on it. So the next morning he decided to indict the firm. Well, when you're a public accounting firm doing audits where integrity and trust is ultimate, if you're an audit committee chairman for a public company and you say, well, we want to hire Arthur Andersen to do our audits. Oh yeah, by the way, they're under indictment by the federal government. Well, that couldn't fly. So gradually, Andersen's clients left. Now, some of our clients in the Denver office hung on longer than others because they didn't see any problem. They hadn't had any adverse experiences with the firm, so they hung with it. But eventually, the firm business all went away. There was a district court trial where this judge, Melinda Harmon, was the presiding judge, and during the trial, all of the objections that Andersen raised, or Andersen attorneys raised, were objected to. She only, there were probably out of 100 objections, she might have accepted 5 or 6. The rest of them, she didn't didn't go along with. So they ended up being found guilty of obstruction of justice. They went on to the appellate court, and finally it ended up at the Supreme Court. Of course, this is like 2005. The firm basically was out of business in 2001 or 2002. That could be my wife calling saying, hey, it's time to shut up. So in 2005, the Supreme Court got the case, and by a 9-0 vote, they overturned all the rulings of the lower court. A friend of mine got the transcript of that hearing, and he read the transcript, and he said, you know, when the justices were discussing this, they were laughing about some of the stupid conclusions that had come to at the lower court level. And you think about it, so an inexperienced lawyer in home office took her name off a memo, didn't change the memo, but that was obstruction of justice. It kind of smocks of, show me the man and I'll show you a crime. I won't get political and talk about how that might relate somehow to some of the other things we've been hearing about lately. Well, so the firm's gone. For all the partners, their retirement program was gone. Many accounting firms didn't fund their retirement for partners. They just paid that out of current earnings. That's just the way it was. When I retired from Anderson, if you'd asked me, what's your most secure investment? I would say, well, the money I have in Arthur Anderson, that's gold. It wasn't. When things started to unravel, we had what was similar to a deferred comp arrangement, where there's a certain amount of money put aside that you could pull out over a period of time. It wasn't deferred comp, but it was similar to that. And when I retired, I had a choice. I could either take that over 10 years, or I could leave it in there and let it earn interest at 8%. Well, I'm not going to take it out. If I take it out, I got to pay tax on it right now. I'll just take it out over time. So when things started getting a little dicey, I called World Headquarters and said, can I still take that all out in one lump sum? No, we're not doing that anymore. So part of that went away, and then the retirement we had, it didn't kick in until age 62. I was 57 when I retired. So I wouldn't have, you know, at age 62 I would have started getting the retirement pay, and that was gone. But, you know, it's a good Lord, sometimes one door closes, another door opens. After this whole situation, Sarbanes-Oxley came into vogue. One of the things that was common for small and medium-sized companies prior to this was their audit committees were not really qualified. A lot of times a company's CEO would say, hey Doug, you want to be chairman of the audit committee? Yeah, I can do that, sure. So I had clients who had a chair of the audit committee who didn't know beans about what we were doing. We'd get done with an audit, and I think, well, the audit committee should be calling me to get together. We should report on the results of our audit. Sometimes I'd have to call him and say, hey, the audit's done. We need to meet with you and describe what we did and what we found. Oh, okay, yeah, sure, let's do that. I mean, that's not unrealistic. That actually happens. Well, after Sarbanes-Oxley, you had to have a financial expert on the audit committee. Now, there's some leeway as to how you define a financial expert, but it was certainly more stringent than it was beforehand. So when I retired from Anderson in 2000, you know, the company didn't go out of business until 2002. When I retired, I let my CPA certificate go inactive because, you know, that was a great career. That was then. I'm going to do something different now. And I'm not sure what it'll be, but, you know, I'm only 56, 57. I'm going to, you know, do something else. We'll see what happens, see what comes along. So after Sarbanes-Oxley came into vogue, I started getting calls from people that I worked with. One of my former colleagues said, hey Bud, I got this technology company client, have this technology company client, and they need someone to chair their audit committee. Have you ever thought about being on a board? I said, well, no, I've never had. So I started looking into that, and I reactivated my CPA certificate, spiffed up my resume, and started getting on public company boards. And it wasn't volunteer, this wasn't volunteer work, it was for pay. I got stock, or stock options, or restricted stock, or stock options, and cash. I wouldn't do it unless I got paid. And at one point, I thought, well, if I get stock options, those stock options will have value if certain things happen, but does that put me in a conflict of interest situation? I worried about that quite a bit. And I talked to my attorneys and others, and they said, no. I said, that, it may look that way, but that's not the way it is. You have rules and so forth to follow, and all the companies have audit committees, have board members, and they are compensated in a similar fashion. And the value of that is that you are aligned with what management is doing in terms of what performance for the company. That doesn't mean you throw aside integrity and doing the right thing and that sort of thing. So I had I was on the boards of probably 8 or 9 public companies over a period of time. They were small. I was a small, medium-sized guy. I never worked on huge corporations when I was practicing. My experience was all small, medium-sized. And in a way, it was a blessing in disguise, because what I generated in income from those board positions actually was a little bit more, than I would have gotten from the retirement program at Anderson. So, you never know how things are going to turn out, but I'll tell you what, when this was going on, visualize this. Now, I'm with Arthur Anderson. I mean, I love the firm. I think it's the best. I think we're the best. I think we do the best. All that stuff was going through was always in my mind. So I'm sitting there on one night watching the Johnny Carson show, and they have a skit making fun of Arthur Anderson. They had a skit featuring a guy playing the role of the managing partner of Arthur Anderson. They featured him as an idiot. And I'm thinking, that's my firm doing that too. So that's where it ended up, from being sure that you were with the best to knowing that it may not have been. Okay, I got 5 minutes to wrap up. There's a couple of sidebar things I want to tell you about. There's a guy in the Denver metro area that worked for Enron. He worked in their accounting department. I met with him and talked with him. And one of his jobs was to, when contracts came in, he had to go through the contract to make sure it met the requirements for the income recognition that they wanted. Well, after Enron went asunder, the Justice Department interviewed a lot of the Enron employees, and he was one of them. Now, when the Justice Department does this, and Patrick is smiling, so he knows probably, but you're on your own. The company's lawyers aren't with you anymore. You are on your own. So you hire your own lawyers. And guess what? You paid for your own lawyers. You can't rely on the company to bail you out. So this guy, for about 6 or 7 years, was being investigated by the Justice Department, and he was paying out huge numbers in legal fees, and they said, don't tell anybody what's going on. Don't even tell your wife. And why was that? I'm not sure what's behind that, but those were the instructions. And maybe it was because if it's discovered during the discovery phase, if they find out that you had talked to your wife about it, then they'll bring her in and they'll start grilling her, and who knows what she might say. She might not know how to answer it properly, so to speak. So he said, for 5 or 6 years, all my wife knew was that these big chunks of dough were going out of our bank account to pay a lawyer, pay a law firm, and I couldn't tell her what it was for. Did your marriage last? Yes, it did. Can you imagine that? But that's the way it is. I mean, I have other friends that were in similar, different situations, but when they were investigated by the government, and the government has all kinds of power. They have tons of lawyers that they can throw into a deal. You're lucky if you can afford one. and it may or may not be the best one in the area. See, there were a couple other sidebars I was gonna tell you about. During the trial, when they determined that Anderson was guilty of obstruction of justice, that was really unfair, I think. That was, and the Supreme Court, when they reversed it all, showed how it was unfair. But I have a memo here from one of the jurors who was on the jury, and during the jury trial, the judge instructed them and said, you don't have to find one person guilty of obstruction of justice. If you can't find one person that was guilty, you can find the whole firm as guilty. So that's what their instructions were.
Wow.
And that's what happened. And this juror said, I have just come through 6 of the most grueling weeks of my life. I was juror number 10 on the Arthur Anderson trial. This was one of those life-changing events for me. I will never be the same again. I think I will forever set this as a timeline in my life. Everything will be viewed by me as before Anderson trial or after Anderson trial. Did I really think that the entire Arthur Anderson company was guilty of the crime? Not at all. Donna, her husband and I were listening to the news last night, and it was reported that the person who started the forest fire in Colorado was a member of the Forest Service. Well, does that mean that the whole Forest Service should be guilty of that? Or just the guy who started the fire? That makes about as much sense. The instructions the judge gave the jury was that if one person in Arthur Anderson persuaded one other person to destroy or alter one document, we had to find the entire company guilty of obstruction of justice. 100,000 employees and partners, guilty. Denver never had anything to do with Enron, guilty. So we suffered. I cried in the jury box when the verdict was read, and I cried again when Rusty Hardin and his defense team came into the jury room and said graciously, thanking all of us for our serving on the jury for 6 weeks, 2 of which were sequestered. I would never have believed that this could happen in America, and I think our government should hang their heads in shame for it. And let me tell all of you, don't ever believe everything you read in the newspapers. I can attest to that too. I was reading the Wall Street Journal articles about this when it was going on, and you could never really figure out from those articles what was happening, because the guys that write for the Wall Street Journal, they're just they're journalists. They don't know about accounting or business really, so they just kind of hit the same high points over and over. And I thought, okay, what was wrong? I never found out about that in the Wall Street Journal. I have to go elsewhere to find that. I think it might be a fair statement to say that the government and the press worked together to destroy a 90-year-old company. However, this was not a company that was under attack. It was the employees at Anderson whose lives have been damaged and changed dramatically by this event. At one point in my notes during David Duncan's, he's the partner on the Anderson engagement, I wrote, may God forgive them for what they have done to this man. I hope every one of you will pray for all the Anderson employees. They need your prayers to help them heal from what was happening to them in the past 6 months. And please pray for me too. I'm having a really difficult time recovering from being part of this tragedy. So she, like all the other jurors, felt like they didn't have any choice but to come back with a guilty verdict based on the instructions that they were given by that attorney. You know, why was it so heavily slanted in favor of the government? Well, the Bush family were very much involved with Enron, and there was a political undercurrent here. You know, the press was really getting after Bush. Enron was going bankrupt. Somebody had to, and Bush, I think, my opinion, somebody had to pay. So I think Bush put the word out to the Justice Department, you got to get me a scalp. And there was Anderson, ready, willing, and able to give him the scalp, because Anderson knew that they'd done some things wrong, and so they were willing to, you know, admit to being guilty of some things, and being willing to change their approach and their policies, but that wasn't good enough for the Justice Department. they had to get the scalp. So I think that's what really motivated and the judge, as we all know, they're not always center oriented.
Right.
This judge knew what her marching orders were, and she handled the trials in such a fashion that it came out the way she thought people above her wanted it to be, my opinion. Let's see, I gotta get down here pretty quick. There's so much information out about this thing that it's hard to kind of boil it down to something that's clear and succinct, but if I've given you the impression that I didn't think Anderson did anything wrong, let me clarify. I believe Anderson did some things wrong. The first thing they should have done is they should have fired Enron. Enron was over their skis, but they were generating millions of dollars in fees. And of course, the accounting firms are businesses like any other business. You gotta, make money, pay the salaries and that sort of thing. So they were very reluctant to fire that big client. And there had been a change in the management of the Houston office over time. I remember 3 people in the Houston office who had retired by the time this came about. I talked to another person who worked in the Houston office, and he and I both agreed that if X, Y, and Z had still been there, Enron never would have happened. That they would have used their leadership and their power to say, okay, the firm is bigger than one client. One client's not going to do this to us. We don't like what you're doing. It may be appropriate, maybe within the accounting rules, but it's too aggressive. And you're creating too much risk, so we're not going to do your work anymore. That's what they should have done. Anderson didn't do that. So they were guilty of some things, but they did not deserve to be killed. The firm didn't deserve to be killed. It wasn't necessary to do that. They could have worked out some things with them and said, okay, from now on, Anderson, you got to do this, this, and this, and we're going to look over your shoulders. One of the things that came out of Sarbanes-Oxley was the PCAOB, Public Accounting Oversight Board. They hired government auditors to audit the audit firms. I was just talking to my daughter-in-law, who's a partner at PwC, and she said, I just came through the most stressful time, but she said, one of my big audits was reviewed by the PCAOB. She said, I lost sleep because when you're doing the audit of a company, you have to make decisions. You might have an hour to decide how this or that should be treated, or how this item should be disclosed, or you might have a few days to decide on it. And of course, you talk to people within the firm and get your best answer, that sort of thing. But the PCAOB auditors come in. They've got all day. They've got all time. They can look at what you did and dissect it upside down and sideways. And sometimes they come back and say, we don't think you came to the right answer here. We don't think your judgment was proper here. And so if that happens, I mean, the audit partner on that engagement, his or her career could be in jeopardy. So my daughter-in-law said, boy, but I lost a lot of sleep over this thing, and the most stressful experience I've ever been through, but came through okay. She's really smart and good. Came through okay, so it was fine. But when I was, and I didn't have to experience that when I was practicing, but when I was on audit committees, some of my companies did go through a PCAOB audit, and the PCAOB auditors would call me as chair of the audit committee and ask me questions about the level of my oversight, what I actually did to provide oversight for that company. Never had any problems with them, but that was part of it. Anyway, that's a lot of information. I hope I haven't confused you too much with the timetable and that kind of thing, but at the end of the day, when the government gets involved and passes regulations, they oftentimes overdo it. But I think most people that are in the financial arena these days would have to admit that even though this has created another whole big layer of regulation and bureaucracy, that the reliability and integrity of the financial reporting in this country is better than it was before Sarbanes-Oxley. Is it worth the cost that we've paid? It you could debate that perhaps, but on an overall basis, it probably was worth it. So, questions? Yes, sir.
Did my third ear tell me that both Enron and Arthur Anderson might have been victims as much of overly zealous and vindictive bureaucrats than anything else?
Well,
Not Enron.
Not Enron.
I think to some extent you could say that about Anderson, because there was a lot of vindictiveness about Enron, because of, think about all the employees who lost all that money, shareholders that lost all that money when the company went down. They had to blame somebody, and the audit firm is oftentimes the handiest one to blame. So, and as I said, I think the Bush family, thank George Bush, and don't get me wrong, full disclosure, I voted for him every time. George Bush knew they were, the press was coming for him, so he had to do something, and I think he was in part motivated to get a scalp.
Any chance this could turn you into a liberal, Bud?
I was vice chairman of Young Democrats in college. I was raised by a farm family of Democrats. I changed parties when Lyndon Johnson, if John Kennedy hadn't been assassinated, I might still be a Democrat. Lyndon Johnson, with the Great Society, every time I turned around, it seemed like his hand was in my back pocket. And I said, enough of that, so I'm switching. Of course, then the first Republican president I voted for was Nixon. And he did a lot of good things as president, but he didn't have a clear rudder either of what was right and wrong. That was disappointing. I've overrun my time, so.
That's all right. Any other questions? I have to say, Bud, that was very educational, and I really appreciate your delving in.